I'm Bruce Diamond, and I want to welcome everybody on behalf of the EPA Alumni Association and the Alumni Association's Academy. Tonight we have the provocatively titled "Has the Supreme Court Derailed EPA's Climate Programs?" And we have a very distinguished panel to present it. Before we start, I just want to mention that while we anticipate having a varied audience today, I know some of you have spent at least a year as a federal employee at EPA. If you're not a member of the EPA Alumni Association, I recommend you look into joining. And it's very easy to do. We'll put a link in the chat, and it's free, which is a great benefit. And now let me introduce, for our distinguished panel, we have a distinguished moderator, and that's Jonathan Cannon, who is the Blaine T. Phillips Distinguished Professor of Environmental Law Emeritus, which I assume means he doesn't have to grade exams anymore, at the University of Virginia School of Law. And before joining UVA, John had numerous positions. Prominent among them, he was General Counsel of EPA. And now, John, if you will take it.
Thank you, Bruce, and good afternoon and welcome, everyone. Thanks for joining us. We're gathered to discuss the effect of recent Supreme Court decisions involving the Clean Air Act and climate change programs. We're also gathered to talk about, if we have the time, potentially cases that are pending that may have an effect on EPA's programs as well. I'm going to give a brief summary of West Virginia v. EPA, which is the main case we're going to focus on, and then I'm going to introduce our illustrious panel, and then we'll get into the discussion. So on the last day of June of this year, which was also the last day of the Supreme Court's term, the court decided West Virginia v. EPA, taking on an EPA rule, the Clean Power Plan, which is famous now, at least within the annals of jurisprudence. That plan had been adopted by EPA in the Obama administration to reduce climate change emissions from the utility sector. EPA based the Clean Power Plan on EPA based the Clean Power Plan on Section 111D of the Clean Air Act, which authorizes the regulation of emissions from certain categories of existing stationary sources. In this case, coal and gas-fired electric utility plants. The statute requires EPA to impose emissions limitations achievable at those facilities with the application of the best system of emissions reduction. That's the statutory phrase. The agency considered technology fixes on a plant-by-plant basis, but it rejected that approach because it would lead to only small reductions in an industry that was a major contributor to national greenhouse gas emissions. And because the utility sector could, as the agency determined, achieve much larger and more cost-effective reductions by changing its fuel mix from coal to natural gas and from fossil fuels to renewables. And that is famously known as generation shifting. I have to keep remembering that's not about moving retired people like me to the side, it's about changing fuels. Reading the statutory phrase best system to authorize a systemic approach to utility emissions, EPA put measures in place to move the industry as a whole to lower carbon emissions. In the opinion for the court, speaking for a 6-3 majority, Chief Justice Roberts invoked the court's nascent major questions doctrine to reject EPA's reading of Section 111 as authorizing, in his words, the restructuring of the nation's overall mix of electricity generation. This elevation of the major questions doctrine is the big move in the decision Although its parameters are fuzzy, the doctrine says that in certain extraordinary cases, courts will cancel an agency's interpretation of its authority in the absence of a clear expression of congressional intent to support that interpretation. In invoking the doctrine in this case, the court cites a grab bag of factors, including the economic impact of the Clean Power Plan, restructuring the American energy market, in the court's words, the vague language and relative obscurity of Section 111D, and the recentness of the agency's interpretation. The court's mobilization of this doctrine allowed it to dispense with the deference that would normally be accorded the agency's interpretation and to impose its own narrower view as to permissible readings. Justice Kagan's dissent argues that careful attention to the language of Section 111D provides ample support for the Clean Power Plan's approach, and she criticizes using the major questions doctrine to override the text's plain meaning. Where are we in the wake of West Virginia v. EPA? An effective agency response to climate change will require innovative approaches. It will likely have broad economic effects, given the scope and complexity of the problem. And West Virginia v. EPA makes it uncertain at best that approaches having these characteristics will pass muster. Yet the statute, under the court's prior decision in Massachusetts v. EPA, which was not disturbed in the West Virginia case, places climate change regulation squarely in the agency's wheelhouse. So what's a responsible agency to do? We'll explore this question with respect to EPA's climate change programs. We'll also explore what West Virginia v. EPA may mean for EPA rulemaking in other areas, and more generally, the ability of EPA to successfully carry out its mission under the new legal regime. First, a quick introduction of our panelists. Bob Perciasepi is Senior Advisor for the Center for Climate and Energy Solutions, of which he was the president for a number of years, and before that was Chief Operating Officer for the National Audubon Society. He served with distinction at EPA as Deputy Administrator and also AA for the Air and Water Offices, successively, not simultaneously, although he could have done that too. Before coming to EPA, Bob served as Maryland Secretary of the Environment. John Cruden is a principal at Beveridge and Diamond. John was Assistant Attorney General for DOJ's Environment and Natural Resources Division, defending and enforcing EPA's rules in federal courts across the country. He has also been president or chair of just about everything in the environmental law field, from the Environmental Law Institute to the American College of Environmental Lawyers to the ABA section on environment, energy, and resources. And recently, John was recognized as a legend in the law by the DC Bar. Gwen Keyes Fleming is a partner at DLA Piper and co-chair of the firm's environmental practice group. She is a former EPA chief of staff and also served as regional administrator in EPA's Region 4. She's held a number of other positions in federal, state, and local governments. Impressively for me, she was elected and served twice as the district attorney for the Stone Mountain Judicial Circuit in DeKalb County, Georgia. Mike Vandenberg is a David Daniels Distinguished Chair in Law at Vanderbilt Law School. He is, like Gwen, a former EPA Chief of Staff, and before coming to EPA was a partner at the law firm of Latham and Watkins. Since joining the Academy, Mike has published numerous influential articles and books in environmental law and policy, with particular attention to the role of corporations, households, and individuals in advancing environmental goals, and particularly in dealing with climate change. So these are our wonderful panelists with a wealth of government, private sector, and NGO experience, and broad experience with EPA, and a deep regard for its mission. They're here to talk about how the Supreme Court is or may be affecting the agency's ability to accomplish that mission. So welcome, panelists. And I'm going to start with the first question, which is really at the core of what we're about here today, which is to talk about the portent of West Virginia, the EPA, specifically with respect to the agency's climate programs. And I thought, since we promised everybody that this would be a session not just for lawyers, that we'd ask Bob Perciasepe, who is the only non-lawyer on the panel, to take a first shot at that question.
All right. Well, thank you, John. I feel after working with all of you for so many years, I could probably pass some kind of bar exam, but I'm not gonna try. I remember in the meetings that we had when we were working on some people on this call undoubtedly were in some of those meetings. That one of my primary high-level deputy jobs was getting kicked under the table by Gina McCarthy and then perking up and saying, what about the word system do we not understand? and then I would sit back down and let all the people start to continue to talk about it. And again, going back to John's introduction, that word system played an important role in them deciding, you know, how they were going to provide the major issues doctrine into this. I see it as sort of a gate you got to go through before you can get to even the traditional Chevron preference or deference characteristics. But let's talk about EPA and what I think this means at EPA. I mean, obviously, the most important thing that this does in terms of EPA is provide some constraint, and it's a significant constraint, but it's not an all-encompassing constraint. EPA still has significant authority to regulate greenhouse gases. This Supreme Court decision, you know, and I was worried about it as it was getting ready to come out, did not go there, as some people say, to impact in any way the Massachusetts versus EPA ruling, which gave EPA the fundamental authority to regulate greenhouse gases, coupled with the endangerment fine that EPA did. So EPA still has the authority to regulate greenhouse gases, and it has this constraint that is now trying to be interpreted by everybody. And let's talk about that just for a second, and then you know, obviously other people have a view here. So I think what's the biggest impact here is it's reduced the agency's options on how it proceeds to regulate greenhouse gases, does not eliminate it. For example, the largest source of greenhouse gases in the United States today are mobile sources, transportation sector. EPA's authority to regulate in that sector is not impacted by this decision. It could be, depending on how if any of those regulations ever get to the Supreme Court and they make this, you know, try to apply this new doctrine somehow. But basically, that authority is still there. EPA is working on those regulations. That's a significant part of the greenhouse gas portfolio. The amount of greenhouse gases coming from the power sector have declined almost 30% in the last since 2005, even without EPA's regulations. Although we could argue pretty effectively that many of EPA's constraints on coal, including things like the mercury rule, coal ash worries, et cetera, have brought the power sector to the point of view is, why do I want these albatrosses in my portfolio? So a lot of work has already gone on in terms of how to reduce the greenhouse gases in the power sector, but obviously a lot more needs to get done. And so EPA will have to turn its attention to doing the traditional new source regulation, the new source performance standards based on, you know, a plant, it's a plant itself. And there's some options there in terms of regulating new sources of gas turbines, for instance, and their modifications. They get modified a lot more than a coal plant did. And so you can catch up with most of the existing fleet, maybe over a 15-year period, 15 to 20 years. So there's options there. The other thing I think you need to remember, I think EPA also now has the authority with the ratification of the Kigali Agreement to start to work with the industry on HFC reductions. And I think what you're going to see, when you look at ozone, fine particles, nitrogen oxides, these have other public health impacts that very much justify reducing those national ambient air quality standards, which will put further constraints on the burning of fossil fuels as a general matter. So you start to look at all these authorities together, you find that EPA is not powerless here to be able to continue, but it won't be as, it won't have as many options as it did. So I think when you couple that with the whole government approach, where you might have preferences for buying cleaner products, or if the IRS and the Treasury Department could get their head around accelerating even more the depreciation of coal plants so that power sector can take those things off their books, you can get a closing of the coal plants perhaps even more quickly. So I'm going to stop there with that general thing, general summary that yes, this reduces the agency's options, but it does not eliminate its ability to act.
Great, thanks, Bob. I invite the rest of you to jump in on this key question.
Bob, how do you react to, I've heard a lot of people say that, frankly, losing generation shifting wasn't that big a deal because most power plants have already shifted to natural gas. How do you react to that?
I think, well, what I said is that the power sector has already reduced its emissions by almost 30% since 2005. And that's substantially due to generation shifting from coal to natural gas, but also not insubstantially to renewable sources. And if you look more broadly at actions that the government has taken, like the Inflation Reduction Act and the bipartisan infrastructure bill from almost a year ago now, last November, you find that there's a lot of incentives there to accelerate the growth of clean energy and reduce the demand for fossil fuels. So I'm not saying it's a non-starter, John, but we're going to be, right now, the emissions of carbon dioxide from power generating coal is still number one in terms of the total million metric tons a year, but natural gas is catching up. It's already beat coal now in terms of the amount of generation, but now it's also starting to catch up in the amount of greenhouse gases. So something is going to have to be done to those natural gas turbines in the next 15 years. And that is a place where EPA could focus, a more traditional approach using carbon capture, some other plant level reductions for natural gas turbines.
Gwen and Mike, your thoughts?
So Bob, one question I had was just whether there's some opportunity for what some of us have called prospective grandfathering for these natural gas plants. It seems like those are looming as a big remaining issue. Is there a way to be issuing permits or thinking about how we regulate them so that we can push a decade or so from now, perhaps when we have more political capital, to get them to either shut down or to more dramatically reduce emissions? Maybe we don't have the political capital today to do that, but are there ways that the regulators can structure regulations to preserve that flexibility in a way in the future that we might not have today?
I'm not sure, Mike, how far that could go, but I do think that you see the shift going from coal to natural gas predominantly because they're easier to operate and the supply, gas supply had been lower cost, and it was getting to be a bigger and bigger burden to be running these coal plants. We may get to that point with natural gas, in the 10 or 15 years, with renewable energy becoming cheaper and cheaper and easier to operate remotely. But I think there'll be probably a need to insert some kind of regulatory regime on the emissions from gas turbines. And again, I'm repeating myself, but that's, if I was at EPA, given all the advice you would normally get, and I don't have all that now, but based on what I know, I would say I'd probably focus on natural gas turbines in the next regulatory round in the power sector.
So one of the things that struck me about this beyond the tone, and I'd love for us to talk about that a little bit in terms of the tone of all three opinions. I can only imagine what it's like in the back rooms of the Supreme Court now. But it seemed to me that the court really wanted to discredit the presence of 111D. I think at one point they considered it a little known backwater section of 111D. And to hear that kind of language from folks who have labeled themselves as strict constructionists, I'm just interested. It almost seemed as though as well they were punishing EPA for not using this provision previously. They kept saying it was an unprecedented use, an unprecedented
Right.
approach. And so again, Bob, with your history with the agency, can you just kind of give us a sense of, I know so often we were looking for new and different ways to achieve our goals under different administrations, and it seemed like EPA got it right this time. They found something in the statute to do what needed to be done in the moment. And so I would just love your history on, is 111D really as insignificant as the court would lead us to believe? And what does that mean for the agency as they try to find new hooks to achieve their goals based on statutory language in the future?
Gwen, that's a hard one, I think, to also answer. This is obviously going to be pure Bob speculation here, but 111D was not used as much because EPA in the Clean Air Program all the way back to the 1970s was, and no pun on the Clean Water Act here, was drinking water from a fire hose and trying to deal with air pollution. And so, and they had specific specific statutory deadlines, even in the 1970 Clean Air Act, on getting performance standards done under Section 111. And so then they got sued to get these things on court-ordered schedules. And so they were working to get performance standards for new sources done. This issue of how do you apply those new source standards to existing sources were left for many, many years to be major modifications. And we all know the tangled wax ball of new source performance standards and new source review. But I have to take a pause there. All right, so but I think that in the traditional sense for several decades, put out those new source standards, wait for the modernizations, apply the new source standards to the modified existing source. Here we're trying to accelerate. Again, this is me speaking. There could be other interpretations. Here we try, and we've done, EPA had done this before a little bit under 111D, but here we try to accelerate the application of controls or restrictions to existing sources over a much quicker time period than the major modification application of new source performance standards. I think I got that right, but all you guys who are, and ladies who are lawyers here can help me out on this one.
No, but I just want to make one observation about Gwen, what she was saying, because I really liked it. I mean, obviously, I was leading the defense of the Clean Power Plan. We had 7.5 hours of argument en banc before the DC Circuit. I assure you, the major question doctrine did not come up. I assure you, we were talking about statutory language, and there's a fair debate about whether or not the statute allows it or not. That is what's missing, absolutely missing out of this argument, is the debate that came before the DC Circuit.
And I was going to raise this point when I got there in the next part of the program, but I work with several social psychologists and others, and I think we have to be thinking about the environmental regulatory regime, and particularly at the Supreme Court level, in a totally different way than almost everyone on this call was trained to think of it. I went to UVA, was taught environmental law as a public law field. It was to be thought of as a form of administrative law, and courts were taking a very careful look. We had a battle between strict constructionists and others, and purposive interpretivists and textualists. I think you can throw almost all that out the window now. I mean, I believe that what is going on in this court, and this is going to be extreme, but is much closer to what we see in the general American population, which is that we are a different people than we were 20 or 30 years ago in terms of the political discourse and the way we think of these issues. You can give a policy to a group of 100 Republicans and ask them if they support the policy and tell them that that Democrats support it and they will reject it. And you can give that same group of people a policy and say that Republicans support it and they'll support it. And the same is true for Democrats as well. So my view is that we've really moved from a world in which there's this sort of careful parsing of language. All of the opinions and future opinions will come out through that intellectual meat grinder. But where they really start is a system one intuition about which group supports which outcome. And I think if we're really going to be smart about designing effective environmental policy moving forward, we have to think really carefully about those kinds of issues, because as Justice Kagan said, she said that text in context statutory interpretation was kind of thrown out the window in this case. And whether you were conservative or liberal in the past as a matter of ideology might decide which of that text in context approach you would take. Today, it seems much more a matter of group identity. Do I like this issue? Do I not like this issue? And to me, that's what predicts so many of these outcomes. And it just means that in a lot of these cases, we're going to need to be cautious about predicting either the method of review that's used or what the outcome is, because the major questions doctrine is just wide open running room to allow this group identity to determine the outcome.
Yeah,
Well, and I think you saw that the court clearly had an agenda. They did not have to reach the issues that they opined on.
Right.
And so to your point, Mike, that's one of the things that concerns me, that our court, which used to be the impartial arbiter of facts and law, is now getting sucked into this political agenda-driven divide. And I think that's going to have even bigger implications than this case, which really concerns me.
yeah, I mean,
I would
that
only
was a-
say that we need to put this case though in context of this Supreme Court's last term. I would, I follow all this in the 233 years of the Supreme Court. This might have been the most politically driven term. Guns, immigration, First Amendment law, and then there was a little case involving women reproductive rights. All of those, we have the opinion of Dobbs' opinion is leaked in advance of their, up until fairly recently, we had barbed wire around the Supreme Court. This was a very significant term that we're just going through. And the case that we're discussing, that John's leading us through today, is just one of many, frankly, where we have significant issues for the country.
But I do think that, and this is brought out in some of your comments, I do think that at least among environmental issues, the fact that this case was a climate change issue drew forth that polarized response in a way that was so striking. Maybe in other cases, even the Sackett case, we can talk about that later, you don't see quite that polarization, but the climate change has become so politicized that that's going to be there. And I wanted to move on, if we could, to sort of broaden out the inquiry. We talked about climate change, but the doctrinal move in West Virginia, the EPA, is a big one that potentially affects all of EPA's rulemakings and the rulemakings of other federal agencies as well, operating under congressional authorizations. And I wanted to just let us touch on the broader points of how this decision is likely to affect EPA's programs in other areas or generally. And I'd ask Gwen to start us off and we can go from there.
So I do think this is going to have broader implications, obviously, on what EPA does. And I have to confess that as I was reading it, I was thinking through this probably less as a lawyer and more as the chief of staff of the agency, because I was really struck by the way the majority in particular went into the archives, if you will, to quote some of Gina's comments in congressional hearings, how it quoted language out of budget documents, and really used that to the agency's disadvantage. And it'd be interesting, and again, this isn't so much a legal comment or question, But to have to now game out and ensure that your statements in all of these tangential arenas don't adversely impact your legal position as you write rules is, I think, a new way for the agency to approach things. And maybe I'm confessing here that I should have been able to handle. Maybe Mike did a better job of it when he was chief of staff, but
Mike had it all under control.
Oh, no.
of course,
no.
of course. But again, that goes back to my sense that the court was really trying to send a message in an area that they didn't have to reach. But I think now seeing what the court's hand is, EPA can redirect and think about the broader perspective, like Mike and others were saying, in terms of where are we, not just on the legal position, but overall across the agency and overall in terms of the larger country issues. How can we position rules and other initiatives in a way that are more, that not only are legally sound, but are more adopted or more appreciated or easier to or harder to attack, I guess, is probably the best way to articulate what I'm trying to say.
Yeah, I think that makes a ton of sense to me. John, do you mind if I go next? Yeah.
No.
So number one, no, we did not have everything under control. I looked to Gwen for advice on that, that's for sure. And let me just say that it is so wonderful to see a lot of faces on this call. What a wonderful group of people, I think, have been at EPA in the past and are now part of this group. It's just spectacular, and it's very intimidating to speak with this group because many of you know these issues certainly far better than I do. But a couple of quick thoughts. One is that we just have to make sure the agency is very strategic. And I think you're right, Gwen. I don't think it's unprecedented. Judge Williams in the Tulloch rule case called out a White House press release that said, "We hope Congress will authorize the rule that we issued today." And he said, I kind of can't do it that way. So that has happened before, but I think you're right. I think what that does is it shows you they're starting with a mental model and an outcome, and then they're building a case on it. And I think we should expect that to occur. From my perspective, what we have to watch out for is what we've sometimes called Disney's law, wishing will make it so. I think we have to be realistic. This court is going to look narrowly at the agency's statutory authority. I also found, and I'd like to maybe John Cruden's views on this, given his time at DOJ, but I thought it truly was extraordinary that the court didn't use a little prudent avoidance and just decide not to take this case. And it does make me wonder, Gwen, as a chief of staff, that now you have to start thinking about, if we don't want the court to review something, how do we shut it down so well that the court won't find some reason to be able to still take it? And I'd be interested in people's views on that.
Well, John, you spent a good part of your life defending EPA's rules. How could the agency make them more defensible in light of West Virginia v. EPA?
So I want to make, I'll do that. I just want to finish where Michael started us, because remember, all of us, that this was not the first time the Supreme Court actually saw the Clean Power Plan. I was shocked when I was Assistant Attorney General. Remember, they sought emergency relief to the Supreme Court. It was Justice Scalia's last vote, but he was not the one who carried the water. It was John Roberts did. Roberts was the one that led the effort that ultimately stayed the case. And so almost from the very beginning, we have a Supreme Court that we knew was going to look in detail at all that, and we saw that. So on the broader question about, what do we do now there? And I know that Bill Riley, who I adore, said this is an indication that agencies ought to stay in their lane. But I have a broader thought about all of that. And it's I think in general, what I'm about to say, not just limited here. Notice that Chevron did not play in this argument, in this case, and the United States did not seek Chevron deference. Chevron has become, what's the Harry Potter guy that you don't name anymore? You can't say out loud. Voldemir. Chevron has become
Voldemort.
Chevron has become that kind of at the Supreme Court level, and so it was not sought or discussed there. Yet in lower courts, it is. It is district courts and courts of appeal across the land. Chevron is still, law. I wrote a Harvard Law Review article not too long ago saying, I started out by saying the Mark Twain quote, that the rumors of my death are greatly exaggerated. And I said that about Chevron too. That said, unfortunately, I think Chevron has made all of us, and I include myself in agencies, a little bit lax. Because we very quickly went to say it's ambiguous because almost all congressional legislation is ambiguous, and then saying you need to have deference. We now need to go through those things that we saw in the majority opinion. We haven't talked about the concurring opinion, which I have more problems with, but on the majority opinion, we need to be able to say, yes, we have the authority, the jurisdiction, the expertise, and we need to focus more on Chevron 1 than 2 and say the statute allows us to do that. Now, I have to say the briefs of the Solicitor General, which were quite good in the West Virginia case, did a lot of that, but it was not picked up by the Supreme Court. But I do think there is more now pressure. And by the way, this is not limited to EPA. John mentioned that I was chair of the ABA section on the environment. Well, while I was doing that, I gave a speech to the administrative law section. And I said, we frankly don't need you anymore because environmental law has taken over all the administrative law. If you look at all the cases, there really are cases that we're talking about. They were not impressed. But nonetheless, this major question doctrine is an administrative law issue. That is going to be the thing that we're going to see in the future, and we're all going to have to deal with it. And that majority opinion is a little bit like the pornography. We'll know it when we see it. I think we're going to struggle, as will all other courts, trying to figure out what the parameters are of the major question doctrine.
So I do want to talk about that for a minute, but John, as you were speaking, one of the things that came to mind, and I'm not going to take credit for this, I'm going to give credit to Stan Myberg, who I think is joining us today, but in this very polarized environment where to get Congress to agree on what the law is generally means they're going to use vague terms so that they can come to agreement. And then the agencies, it seems, no longer have the ability to interpret or be given deference on their interpretation of whatever that word is. And again, if you take the word systems here, I had to laugh out loud when the court said, of course, almost anything could constitute such a system. The word is an empty vessel. Well, you could almost say the same thing about the major questions doctrine. Everything is going to be a major question or be extraordinary, and it's almost too full of a vessel. Everything could be put in there. So I'm just wondering, how does the agency win when it now has to interpret vagueness, but will not be given deference when it does so?
To me, I said earlier that this major questions doctrine, and John, I think you sort of alluded to this, is almost like in front of before you even get to deference. It's like a gate. If you can't get through the gate that this is some big thing, then we're not even going to get to what you want to think about a system is or whatever. And so that is not just an EPA issue. And I think Gwen and John Cruden and everybody have already mentioned this, but this was an utterly gratuitous case. I mean, the power sector had already exceeded the reductions that were envisioned in the Clean Power Plan, and it was essentially in the world moot. And so the only reason that they took it was they wanted to make these statements. And I think they used this because not only did they want to do something about climate change, but I think they also wanted to start to put some constraint, as the conservative line of thinking would go, on the administrative state. John, you were just talking about administrative law. They want to reduce the flexibility that the executive branch has. And it just gives the Supreme Court almost a legislative authority over both the congressional and the executive branches by they sit in judgment of whether this is too big a deal that the two of them have to go back and figure out what they really want to do. So I think this exceeds, EPA. This gets to health questions, safety questions, almost any kind of regulatory program. I mean, if the so I'm not going to go on on that, but I mean, this is really a door opener, laying down the frame that is very huge, as you just pointed out, Gwen.
Gwen, I would just go ahead.
No, I was just going to say, I think, Bob, you're right. One of the things that keeps popping up in my practice is, what does this mean for the SEC's rule on climate disclosures?
Yeah.
Climate is still a hot button issue. And if you're going to say OSHA can't do the types of things that it did with respect to trying to protect public health or trying to protect workers during the pandemic, if HHS can't do some of the initiatives that it did, are you then going to say, well, the SEC as a transactional financial industry has no right to step into the climate space?
I think we have to be careful how far we go on that. I mean, the Congress has authorized the executive branch to do major things. So, I mean,
but I think the thing to think about there is, yes, Gwen, I think the climate word will be blood in the water for the Supreme Court on the SEC disclosure. It won't treat this case it'll treat it like a climate case when those regs come up. And so my own view would be on that, and my guess is they're doing it right now, is that the SEC ought to very carefully write that preamble and structure the rule when it gets finalized so that it can be connected to a material risk to a reasonable investor, and sort of stay within the core of the SEC's authority. From my perspective, I'm not so worried about that because I think so much has gone on in the private sector. And Gwen, I looked you up before the program. I see you do ESG advising, for example. A lot of things are going on now because, from my perspective, we've had essentially one major new pollution control statute since 1990. I would put the Lautenberg amendments in that. I know we've had some other really important ones, and that's the 2016. So that's one in 3 decades. I would argue that we have really moved from a polluter pays system. And Gwen mentioned that the Supreme Court has sort of shut down agencies' ability to broadly interpret their statutes. I would say the polarization and sorting of Congress has shut down Congress's ability to adopt major new pollution control statutes. So if you look at the 3 most important greenhouse gas emissions reduction statutes recently, I would say, of course, the IRA, last year's bill, and as well the bill in response to the Great Recession during the Obama administration. All of those are subsidizing good behavior.
Right.
Those are beneficiary pay statutes. They're not controlling bad behavior. They're not polluter pay statutes. So from my perspective, one of the interesting things for the agency, and this gets back to work that John used to do at the agency, John Cannon and others, and a lot of people on this call, but I think we need to be thinking of ourselves, if we are EPA, as a grants management agency, a subsidy management agency. If we want to have an important role to play here, is I don't see Congress giving a lot of new polluter pays type regulatory authority, and I don't see the Supreme Court giving us a lot of that. So there's going to be some narrow interpretive things, but that means we need to be structured and thinking of ourselves as, how do we combat environmental problems if what we principally are doing is doling out carrots rather than carrying a stick?
I concur with that.
Yeah. And I just point out the reinforcement mechanism. If the court is basically saying EPA can't do it under existing authorities because Congress hasn't been specific enough, the remedy is to send EPA back to Congress. And as Gwen and others have mentioned, Congress is not in this business now, at least in a regulatory mode. So you're really stuck in that arena, and therefore a lot of pressure on the grants and so forth.
John, you mentioned it, and we started that this case has already had an effect elsewhere, and since Gwen brought up SEC, I want to actually separate the majority opinion, which talks about major question doctrine, from the concurring opinion, because that is different. The concurring opinion is really a separation of powers, and they really call it non-delegation. And if you remember, we've been there before. There's so many people on this audience that know how we've fought through the Whitman case and non-delegation. But that Gorsuch concurring opinion is all about really non-delegation, saying in some instances Congress can't do it because they would be giving away their authority. The significance right now in my mind is the Fifth Circuit just a few months ago invalidated the SEC administrative law judge program, saying it violated the non-delegation because there wasn't intelligible principles as to how they should act. That case is another case that actually could come before the Supreme Court. And so I think we need to keep our eye on not just major question doctrine, but this whole concept of both separation of powers and non-delegation.
Two optimistic points. I guess optimistic. I do think that that the point that Bob Percisepe raised early on, that the utility sector was already largely achieving the Clean Power Plan goals, also tells us the extent to which what we really have out here is the deepest mismatch between the preferences of the American population and the composition of the Supreme Court and the composition of the other elected branches of government than we've had in a long time. And so I think that gives us two opportunities. One is that companies can't gerrymander their markets the way members of Congress can gerrymander their districts. And they are being forced to respond to this pressure. And so I think there are a lot of things EPA can do through procurement, through information disclosure, and a whole range of other things to try to drive private sector reductions, even absent congressional requirements. And the second thing I would just say is maybe there's a little bit of an opening there as to where the Supreme Court will go in the future, because they realize that only one of their members was both appointed and confirmed by senators and a White House representing more than half the American population. They have a legitimacy issue, and there is a point at which they're going to have to respond to that. I think it's a while before that will happen, but I think we'll see with Dobbs and other cases, they're going out and giving talks about their legitimacy. But that's not the way you get legitimacy. The way you get legitimacy is to align your decisions with the preferences of the American population, and they're out of sync right now. So I do think there's a chance that we will see some realignment. And in the meantime, maybe we can use some of these other forms of subsidies and pressure on the private sector to buy enough time so that things like climate change don't get out of control on us.
So Michael, you're probably the leading academician in the United States talking about what corporations are doing and the market forces, and under the rubric, I think, that you developed of private governance. Is that a way forward?
Absolutely. And I think there's a lot that EPA can do. Mike Mahoney and Sally Fisk and I had a piece called Moving in Sync, where we talked about how EPA could try to recognize and promote the idea of the Science-Based Targets Initiative. Those are companies that are committing to a carbon glide path that we would want them to. If we had all the regulatory power we would want, I think EPA would be playing the role that SBTI is right now. And so looking for ways to stimulate that, I think, could be quite important. I think supporting supply chain contracting initiatives, surprisingly important. I just had a piece in the LA Times reporting on a study we did that showed that 80% of the largest companies in the world are imposing environmental requirements through their supply chains. So there's a gap filling thing. It's particularly important in the part of the country I live in now. And in the US Southeast would be the 6th or 7th largest country in the world in terms of emissions, just based on the emissions from the Southeastern states. And our states are certainly not going to fill the gaps in federal action. I think also harnessing the working from home transition. A major change is occurring, as everybody here knows, with working from home. And that provides opportunities to either increase or decrease carbon emissions, depending on how we focus on it. And I think about that a lot of the money, I don't know exactly how much, but a lot of the money in the IRA, if it ultimately gets appropriated and used, can also stimulate a lot of private sector change that will be very hard for the Supreme Court to stop moving forward. Although states like Texas and Oklahoma are trying to do some of that.
So we've looked at implications of West Virginia v. EPA for EPA's programs, including climate change, but not limited to that. And we've also, through Mike, discussed what other actors may be doing or able to do within that setting. But we haven't talked much about the role of states and localities. And I wondered whether it's worth at least spending a little time on what states can do, what they are doing, whether that will be affected, and in what way, by West Virginia v. EPA Gwen, you've had a lot of regional and state experience, including the DeKalb County prosecutor. So what do you think?
Well, and as many on this call know, the Southeast is special. And so of our 8 states, we had 7 that were led by Republicans, and the 8th at the time was led by Governor Beshear in Kentucky, and we were at odds on coal mining. So learning how to work across the aisle or work across issues, I think is always fun. Let me put it that way. I think legally, this case really doesn't do any harm or prevent any states from moving forward with whatever climate goals, legislation, initiation, even grant programs and more carrots, as Mike and others were talking about. And I think that's just the natural dynamic. Anytime the federal government is perceived as having to step back, either by choice or deprioritization of an administration, or as being limited by the courts, as some might argue with this case, you see states start to step up and try to cover those gaps. You also see, I think, what we might want to call more vigorous grassroots efforts as well. And I think that falls in line with what Mike is talking about. You know, obviously in the legal context, that's more citizen suits, but that's not the only place where states can be influenced by many of its constituents. And it really goes back to all politics is local. And so in the federal government, we may feel removed from what is happening on the ground, but the states are less so. And I think they're going to try to ensure that the protections are provided, that goals are met, even in the absence, or particularly when the federal government is not able to go as far as it wants to.
I mean, one
Mike,
thing you
you're
can-
on mute.
one
So,
thing you-
John, one quick thought on that topic. Has anyone, maybe Bob or John is following, or Gwen might be as well, the pork producers case, which was argued just this week. And as I understand it, California adopted a rule protecting, an animal welfare rule protecting pigs, and it only applied to about 1% of all the pork developed in California, and 99% was imported from other states. And it sounds like the Supremes gave it a pretty tough look, and that they might try to shut down what would otherwise be emerging, which is the states that care about environmental issues trying to impose their standards on other states. And the Supremes might shut that down too.
I was just going to point out that California has adopted a no emitting vehicles could be sold after 2035. They've adopted that rule, and under, I think it's section 187, I could have that wrong, it could be 189, but I think it's 187, where states can opt into the California program. Well, New York State, where I currently live, and I think Massachusetts have already started the process. I think Kathy Hochul, the governor here, signed some agreement already to opt into that California regime, where in the state of New York and in the state of California, and maybe other states will join, automobile manufacturers won't be able to sell internal combustion engines after 2035. So in the meantime, you also have EPA working on regulations, probably that'll go out to 2030 or 2035 on a declining emission path for fleet averages. So there's that symbiotic relationship between state leadership and maybe the EPA being still able to follow with the authority they have on transportation issues. I don't want to lose track of the fact that EPA still has some substantial, very clear delegation of authority, on some aspects of the greenhouse gas spectrum.
But Bob, I think you're right. And I think that those efforts to regulate the transportation sector are all positive. But I will say there's another case where you could easily see that being challenged on using the major question doctrine, right? Your big economic impact affects a lot of the United States. We know that as 16 states right now are following California's clean cars initiative. So it's another area we could see, another state, another West Virginia like challenge, only this one to the waiver that California has to do all that.
Yeah, well, Congress has made it pretty clear in the 1990 amendments. They would have to say that Congress was confused. I don't know. But yeah, they could do that.
Again, yeah, I think we should just all be aware they could be doing that. One other angle to take a California standard and apply it nationwide, which I thought was fascinating, and some of you all may have worked on, was this notion of when California sets its own standards, that they then get the 5 major automakers to buy into that and to apply those standards nationwide. Again, there you have de facto national standards where California, and it's being done with a private agreement. I think that's fascinating. And maybe we'll see more of that because it's, again, a little harder for the Supremes to get to that, although maybe they could try to do so under some antitrust approach or something like that.
Let's not give them any ideas, Mike.
Yeah, well, we're going to see major questions coming up in virtually every case, I think, at least in my
Well,
EPA rule.
Somebody will try to pull it, if they figure they can get themselves in front of the Supreme Court.
Well, I wanted to, before we move to questions from the audience, I wanted to open the discussion for some other cases that are pending before the Supreme Court, including one that doesn't appear to involve the major questions doctrine. And that's Sackett v. EPA, which is a Clean Water Act case concerning the scope, the perennial question under the Clean Water Act, which is the scope of the agency's jurisdiction over navigable waters defined as waters of the United States. And in this case, the issue focuses on the agency's jurisdiction over wetlands adjacent to traditionally navigable waters or tributaries of traditionally navigable waters. There was oral argument earlier this week, I think, or last week, and major questions doctrine may have surfaced, but it really wasn't a central focus. The justices seemed more focused on the actual language and its pragmatic implementation by an agency over a long period of time. And I'd welcome your thoughts about, and this requires reading the tea leaves to some extent, your thoughts about what signals the court might be sending or might choose to send in this case. It seemed that the court was, at least on the whole, more sympathetic to EPA's position, or at least more understanding of the difficulties that EPA was facing in implementing the statute. And there were suggestions, at least, of a more pragmatic approach. Should we take hope from that, or is it too soon, or is this just not the kind of case that would give us a meaningful signal?
John, I want to go back to how Bob started us out on West Virginia, saying they did not have to take that case, right? West Virginia, you didn't have to take it. Right. That is absolutely true in this case as well. Right. It's already been up to the Supreme Court before. Remember, they had to decide whether or not it belonged in the district court and the Court of Appeals. By the way, we filed a brief that said, if you let it go in the district court, it'll be chaos. They put it in the district court anyway, and it was chaos. But nonetheless, this is a case that had already been set aside. The administration already said we're not going to follow it. We're going to redo it. Ordinarily, I would say, in all of my litigating history at the Department of Justice, virtually every court stayed away from that because you wanted to wait and see. You wanted to wait and see what is the EPA going to do, what is any administration going to do, and they took it anyway. So that's point number one. Point number two is I just lectured in general about the Supreme Court's last term and pointed out that they reversed 82% of the time. 82% of the time, and one circuit stood out, the Ninth Circuit, and it was 100% of the time. So anybody that looks at this one and says, oh, they're going to say good things about the Ninth Circuit, that's pretty unlikely. They will do that. And for all the people who said, my gosh, they didn't say anything really bad about Kennedy's, Rapanos concurring opinion that everybody understands it, but they did not know because you could not see the court. Kennedy was sitting in the front row of that Supreme Court argument there. And
Was he-
so,
Was he there on purpose?
yes, very much he was there on purpose. Absolutely. And so I think this one's very hard to call, what they're going to do here. But I do not predict them going out of their way to say nice things about the Ninth Circuit.
Yeah, I would concur with John. I mean, I actually think it was not a bad thing that he was sitting in the front row there, but I mean, because some of his accolades are up there, acolytes are up there, and maybe they'll have some sympathy toward his opinion. But you're right, and I think we had a commenter, Gene Fox, so I think sent a comment. I mean, they did not have to take this; they could have waited for ripeness, as we used to call it. After the EPA did its looking at all the different things that have occurred, the 3 opinions, the last time this went through the Supreme Court, the Obama version, the Trump version, and could they find a way to navigate through that would bring people together? And they took it anyway. So who knows? Given the history that John just talked about what this court is about, it's hard for me to believe that they're not just going to make it harder to deal with wetlands. However, listening to whatever the news reports were, I did not sit in on this case, but listening to what comes out of it, there's some perhaps false hope. Maybe I hope.
And there was a positive part, Bob, I think they were doing your traditional statutory argument. And unlike West Virginia, the Solicitor General did seek Chevron deference in this case as well. So separates it from West Virginia. Right at the very end, Justice Alito kind of put in play the major question doctrine, sort of, but did not get much traction.
Yeah. So, I guess we have to wait and see, as obviously we do. But at least it didn't come across during the oral arguments that they had a completely fixed agenda. It didn't come across that way, but.
I would also say this is Justice Jackson's first argument. She came prepared. She elbowed other people aside. I like listening to her.
Yeah, that was impressive. That was impressive.
There's a famous proverb that predictions are hard, especially about the future. It gets attributed to Mark Twain and Yogi Berra. We did a little research on that because, of course, that's what we do. And it actually goes all the way back to an old Danish proverb. But anyway, it's still true. It's still true. If I had to predict, I would say some version of the Rapano-Scalia decision is what we're going to end up seeing. And I think the rest of it, to me, was window dressing. I hope I'm totally wrong about that. I would raise one point on the major questions doctrine that I heard Lisa Heinzling raise at one point at a workshop, which is, you can essentially boil it down to, if it expands the federal role, it will be rejected. And because when you think about it, when has the court applied the major questions doctrine to an interpretation of a statute that narrows the federal role? Right? If it's truly a neutral doctrine, it ought to be applied neutrally as well. It's really not doing that. And as I think some people were saying in the chat, at some point we just have to recognize that if you start with the intuition that we need a smaller government and that dominates everything else, then you just use the MQD to sort of get you from here to there. And I worry that that's where we're going to go. I don't think it'll play much of a role in Sackett, but I think it does go back to the conversation we were having before.
Okay.
I would agree. I can't game this one out. And again, I think it for me, it just needs to be another data point on the board now that we have this 6-3 divide. But I will say that I am going to start using MQD from now on, because it's a cool way to describe what we're going through.
And one other just quick thought, John, which is just, again, we have an effort with the Environmental Law Institute to develop model environmental supply chain contracts. And in each of these areas where the Supreme Court and Congress start taking away federal authority to protect the environment, that's a gap that's opening up that can be applied. So For example, with wetlands, we could begin to try to put pressure on those developers and those retail units that do business with them, et cetera, to say, if you don't include a no wetlands loss provision in the development agreements you do, we're not going to do business with you. And get investors to do the same thing, and get insurers to do the same thing, and get lenders to do the same thing. So I think we're going to have to, in a lot of these areas, not because I want it to, but we're going to have to fill some gaps and be aggressive about doing that in cases where the combination of the Supreme Court and Congress are hobbling the agency on some of its core environmental functions.
Great. Thanks, everybody. That's great. Now, Bruce Diamond and I were going to have a series of signals, which we never quite worked out, about when to switch to questions from the audience. And I have another question, but Bruce, are you ready to go? Or
Am I back on?
yeah, you're back on.
Okay, good. Okay, well, so far we don't have too many questions. I have one of my own, so I'll take the prerogative of asking it, which is reading tea leaves even beyond where we've gone so far. Are there cases out there circulating through the federal courts that may be ripe for the Supreme Court to reach out and grab to make additional statements, such as the statement they made in the West Virginia case?
I'll defer to John Cruden on the environmental cases. The one thing I would just want to make sure everyone keeps an eye on is the independent state legislature case, which I think has just explosive potential.
And there's also, Bruce, there's also a VA case out there, which has, now the Supreme Court does sort of repetitive considerations in their cert meetings, and this one has gone through 3 or 4. But the primary issue is that environmental case is whether or not you would actually do away with the Chevron doctrine. So that's in play right now. Cert has not been granted, however.
A question that has come in is, what is the role of other government agencies? And I think this goes to the consumer agencies. For example, the Department of Defense, with its enormous budget. I would add NASA and its budget. Department of Energy and some of its functions has an enormous consumer budget. What role can they play, going back now to climate, what role can they play in this, in going forward?
Yeah, just let me start the thing here a little bit, Bruce, but I think what the Biden administration is trying to do is look at the whole government approach, and they're looking at everything from SEC and climate disclosure to purchasing preferences for lower carbon versions of fountain pens to concrete, and if you extend that to the Department of Defense, it will be a significant pressure point. And I think the point here is that, and I think as a climate advocate myself, I try not to get, and as much as I love EPA, I try to get into the position that EPA can't solve the climate problem by itself, even if it had not been restricted a little bit in its ability to interpret something like the word system. It doesn't have the authority to deal with changing the economy, and so getting consumers to start consuming less fossil fuels, and I think Mike put his finger on this. Through 20 years of trying to get policy done in the United States Congress, 25 years on climate change, it almost always comes down to incentivizing good things versus punishing bad things, and that's where we see ourselves now. We now have the Inflation Reduction Act, which has billions of dollars to incentivize cleaner energy types of approaches. This can work if we do it enough, and it starts to reduce the demand for fossil fuels, and then companies who are in the fossil fuel business start to say, well, maybe I need to get out of this business if the demand is going to keep going down over time. Automobiles is a classic example. If indeed we can transition them to electric over the next 20 or 30 years, the demand for oil is going to go way down, and so will the price. So I think what we see, Bruce, is that that whole government approach is really probably the most efficient way to do it, regardless of what constraints may be placed on any particular part of the government. Now, you have
Well,
to have a government. You have to have a government that wants to do something about climate change. So I mean, there's that big
There's that.
question.
Right.
There's that.
I echo everything that Bob is saying, and I think you saw it literally from day one with the Biden administration. I think you also saw it to the extent that we made some inroads during the Obama administration as well. But when you look at the first executive orders, whether it's 14008 or some of the others that came out within Biden's first week, you see him emphasizing the federal government is going to use its procurement power to advance climate initiatives, that they created the climate task force, this climate advisory council, to really explore all of the many ways that the federal government can use its subtle powers, if you will, or its inside game, as I used to call it, to advance these priorities from the administration. And for those of you that know me, you know that I also have to mention on this call the importance of tying some of these climate initiatives to the other pillar and focus of one of the primary pillars of the Biden administration is advancing environmental justice and ensuring that as we move forward with these climate initiatives, that we are having all boats be raised with this tide and not sacrificing parts of our community as other parts are able to advance and get some of these incentives and benefits. I think that's why you see so much focus on environmental justice and a lot of these carrots that are coming down through funding in other areas.
No, I agree with that.
I want to do a shout out. Ruth Bell put on a comment on the chat board pointing out that during Obama administration, DOD actually did quite a bit and wrote extensively on climate being a national security issue. Frankly, we lost 4 years from some other administration, but they're back, and we're seeing enormous concerns by DOD for sea level rise and all those things that we all know is in their future. And I do think it's a national security issue, which is another prong of this that we really haven't talked about much.
And one of the things government can do sometimes is take the Hippocratic Oath and do no harm. And an example I would say is, the Trump administration went after the automakers when they were working with California to try to adopt those tailpipe standards. And I worry that in a good faith effort to try to avoid anti-competitive effects, we might discourage companies from working with investors to decarbonize. We're going to need to interpret all of the statutes that all the different agencies administer, including DOJ and antitrust, in ways that allow us to achieve the workaround from the failures of public governance that we're seeing. And if we fail to do that, I think it's going to undermine a lot of the other options that we have. And we can see that in a bunch of areas. One other thing I would just say is people tend to poo-poo a carbon disclosure on products a lot, but we just published a paper in Nature Climate Change last January that argued that a lot of the benefit of that is not even a different purchase of products based on that, but that companies actually reduce the carbon emissions in their supply chains when they're forced to disclose the emissions, even if consumers won't pay more for low carbon goods. So just another reason why that's a sort of a low investment area that some other agencies can play a big role in.
I see Mike Levin on my screen, and I know, Mike, you're writing a book, I believe. So
yeah, but not on this.
not on this? All right. I thought you had a question.
I do. Yeah. Thanks, Bruce. I want to come back to John because I don't think the thought got fully fleshed out. Would you address Justice Gorsuch's concurrence on non-delegation in a little bit more detail? Because for me, that was sort of one of the most surprising things about West Virginia. I think there's a real time bomb there because it goes way beyond major questions and its implications, and essentially implies that you not only have to have a clear authorization from Congress to do something, but you need to have a detailed roadmap before the court will consider it legitimate, at least in Gorsuch's view. Nobody else joined in that opinion, I don't think.
No, Alito joined, Mike.
I guess that's right. I guess that's right.
And so I'll do just a shorthand, and that is the majority opinion. Let's focus on the majority opinion is really, be clear. A major question is it's got to be extraordinary. It's really a limitation on the executive branch and taking away options, as Bob led us through. But if you look carefully at the Gorsuch, it's really a limitation on Congress, that Congress cannot delegate its legislative authority. And so it is different in kind and frankly more dangerous. And it's Gorsuch that lays out the factors, right? He's the one that lays out all the different factors. Chief Justice Roberts does some of that, but Gorsuch's are different. And I think that's dangerous to follow that too far, because that was not the majority opinion. The majority opinion is actually bad enough, but not as bad as the concurring opinion by Justice Gorsuch.
Yeah, I would agree with that analysis. I just think it's something to watch because, I mean, who knows how that's going to spread among the 6 justice majority in future cases.
I like that concept of spreading. Try to probably John Cruden, remind me, do you remember American Trucking versus EPA? Wasn't that a non-delegation of the authority to set a national ambient air quality standard? Wasn't that the key to that case?
It was, absolutely, and it's the case that we cite for the non-delegation doctrine not applying out there.
That's a great example, because it's a case in which we thought the non-delegation doctrine was put back to sleep, and now it's waking up again, or at least trying to wake up in portions of the court.
Right. I mean, one could only envision the United States Congress trying to set an ambient air quality standard.
Oh.
So I have a question, sort of moving to the macro level, and you can decide whether to indulge me with this or not, but I'm thinking we have 2 former chiefs of staff of the agency here with us. We have a former deputy administrator, and we have the premier litigator of EPA cases. If you were administrator, what would be the one thing that you would do to redirect the agency, if anything? Your answer could be steady as you go, just keep doing it smarter and better and so forth. Or maybe you would want to do something to change, to a macro change in the agency, its emphasis, its way of doing business, to try to accommodate this new legal landscape that we're encountering. What would that one thing be? Yeah, Mike.
I don't mind taking a first cut at that. And so I think the first thing that you would just want to be a little humble. I don't think that you can solve a lot of the problems we have as the EPA administrator. And I don't think the agency should beat itself up given the hand it's been dealt. But I would say I would embrace the fact that we are moving from a polluter pays to a beneficiary pays role. And I would say, let's make sure the agency plays an incredibly important role, that this doesn't become the Department of Energy climate program or whatever, because I think the agency historically has been so focused on its regulatory mission. Of course, it's had huge grant programs and so forth, but that to me would mean you've really got to focus on how do we design programs that account for human behavior, that really actually get the outcomes we want? How do we manage them in ways so we don't get embarrassed later with waste, fraud, and abuse? I'd go back and study the way FDR managed a lot of the New Deal programs. They put an extraordinary effort in because they knew that they would be criticized not for the outcomes of the programs, but for mishandling the money. So they really put a lot of effort into doing that well to anticipate the harms. So I think that would be one of the key things I would do, is just to say, let's embrace that part of our mission. And it's going to take some different focus and some different staffing in some cases. But let's make that, because we were always the bad guy, so to speak, in different settings. And it was always other departments that had happier congressional committees because they were doling out goodies. Well, now you're in the goodies business. Embrace it and do it really well.
I would have to agree with that. I think EPA was always known as the environmental cop on the beat. And I think obviously it still has that role in the enforcement context to protect communities. But there is this opportunity to meet the moment. And instead of being, and almost be that benevolent cop, more of the community cop out playing basketball with the kids in the community, you know, to Mike's point, doling out money as opposed to just being there to enforce when things go wrong. Obviously, that's still a strong component. But I agree, it is a to make sure that the team inside the agency still feels empowered as it takes on this new role and doesn't feel as though it's lost anything, it's actually gaining something. And from my perspective as a prosecutor, I always want to know where my opposition is or where the other people on the chessboard are so that I can craft a strategy. And some of you have heard me say that, to me, environmental policy is like multi-level chess. You've obviously got state, federal, local, have always had the court, and now the court is showing its cards. So with that knowledge, you can game out a strategy and just try to limit the number of cases that reach the court or build the type of arguments that are so strong, the court has little ability to attack or undermine whatever regulations you come up with.
I'll go next, because all these are great comments. I think EPA has a congressionally mandated mission that it must sustain, or it'll be sued to do it. But it must sustain. It has established over the last 40 plus years, it has established a baseline of protection that has to be preserved. Now, the problems of the 21st century are very different than the problems of the 20th century. And it would never be given the authority to solve microplastic particles, climate change in its totality, pharmaceuticals in the drinking water, or coming from all these different sources, source control. It's going to have to be a leader in a broader partnership of protection. And so we see that a little bit. We've already discussed it in climate change, but some of these other huge issues require EPA to be the sustainer of the baseline and modify and align that baseline, which wherever we're going to solve those bigger problems, which requires more people, more institutions, including the private sector, as Mike has brought out many times. The private sector is in a very different place than it was, 30 years ago, and they need to be brought into this in a more powerful way, as does the community level that Gwen pointed out. That's the kind of convening I think that EPA could be successful at, taking that leadership role. But we can't walk away from that baseline of protection that we created for the United States, and that is being emulated in other places around the world. It must be sustained.
I like what Gwen and Bob and Michael have said. I have one more. I think most of us have grown up in an environmental world where it was very much top down. Congress created laws, EPA did regulations, and people, many of them listening today, enforced or interpreted or helped corporations. And I don't think that's going to be the model for the future. I think it's bottom up. 2/3 of our youth are solidly behind climate issues. I think President Biden would hold a government, but I think we have a hold of the nation. We need the energy that we saw in Earth Day, original Earth Day, that created and mobilized so many people. And I think EPA has a role in talking about the very issues that we're talking about today, that John Cannon is leading us through, because the vast majority, Republicans and Democrats alike, still want a good environment. They still want clean air. They still want good water to drink and water to recreate in. And we need to build on that so that our future is bottom up, where it's people that are moving Congress and whatever administration is in power. So that's my thought, John.
Well, that is a rousing conclusion, John. Appreciate it. But do we have more questions, Bruce?
We have two more.
Okay, great.
if we have time. One of them is, how do the panelists think EPA can support ESG investors, given their concern with making rational investments and risk avoidance, when some states are attacking ESG investment?
So I think there are several fundamental things. This is an area that I do a lot of work on. And I think everyone on this program who isn't familiar with the idea of the universal owner theory or common owner theory should just Google those terms and become familiar with them. The underlying idea is that modern portfolio theory has induced large institutional investors to own stocks and big index funds. And so they now essentially own the economy. They don't just benefit by any one sector succeeding. And so I think a lot of what's going on with ESG investors is actually not socially responsible focused or altruistic focused. They literally just own the risk of society as a whole, and they don't benefit economically if one of their companies in their portfolio makes money by harming the others. And so I just think that's worth understanding behind as a driving force behind what we see on the ESG front. I think, as Bob had mentioned before, I think continued significant, substantial enforcement of the law is incredibly important. I think ESG collapses if the bad guys get away with it, so to speak. So I think that's a fundamental role the agency can play that we shouldn't underestimate. Secondly, I think the provision of as much data as possible to allow the companies and the investors to act in a smart ESG way is a critical feature of what the agency can do. And I think when possible, rewarding companies for having done this, whether they're investors or companies, and conducting programs and so forth that don't expect perfection, because we don't expect perfection from cities or states, but expect a high level performance and then reward them for doing so. I think if you do those things, then you're contributing substantially. But it does start with enforcement, because anticipation of future government regulation is a piece of the driver here.
I would agree with all of that. To avoid that sort of punishment is a great motivator for many of my clients, but I've also talked to them extensively about, rather than just thinking of how to build a compliance plan that is enough, that meets the letter of the law, is I talked to them about some of the innovations and technologies that might catch the administrator's eye and get a visit from Deputy Purchase Epi or from a regional administrator. Because again, those pictures of one of these high-level federal leaders touring your facility are worth 1,000 words in terms of putting that in your annual report and everything else. So the opportunity to build positive relationships and not just avoid the negative ones is another way, is exactly Mike's point in terms of where EPA can straddle both sides of that fence.
And I would just add very quickly to what Mike and Gwen just said, and I pointed out the private sector's growing role here, is there needs, and Mike has written on this, obviously with the article we were talking about, I got a chance to be a commenter on it, but the idea of being able to provide credibility, and that the work that's being done in the private sector is not greenwashing. How to build that governance that, we used to only provide credibility by, discharge monitoring reports. I love them, by the way. I just want you to all to know that. But I used to do them for the city of Baltimore. So but that is one way to make sure the baseline is there. But this idea of getting beyond that, of changing the way you make your products, changing the way your supply chain works, dealing with all these big macro issues that can change, these larger societal environmental issues. Who's going to be there to make sure that those are credibly happening? And it can't be, the old way we used to just monitor the emissions. It has to be some other way. And this idea of some kind of innovative or hybrid governance structure that can gain public credibility, I think is an area of that needs exploration. I think somebody in the comments mentioned the old regulatory negotiation processes we used to do at EPA back in the 80s and maybe into the 90s. This is probably a bigger deal than now, because these tended to be specific, but some of the elements of that are here.
Yeah. All right. Well, Thank
We
you.
have time for any more?
Yeah, I think we're shifting to breakout groups now at
Okay.
3:30. Although it's up to Chuck.
Well, we could take a short one before we
Okay.
go into breakout room.
Okay. One more question then would be, building on what's been said about the role of other agencies, how can EPA be more effective in creating cross-agency teams for key areas of the economy and to combine regulatory and non-regulatory sticks? I'm going to add personally, having worked at both EPA and Department of Energy, I was struck by how little coordination normally occurs between those agencies.
Yeah. Yeah, that's a ripe area for building on the baseline, you know, you know, I have this vision here of expanding the baseline to take over climate change and be the regulator of all greenhouse gases, or making sure the baseline is there that has a role in the greenhouse gas, and then having other, you know, whether it's the carrots that the Department of Energy has, the tax incentives that the Treasury Department has, all those things where, you know, state activities, corporate commitments, all those things working together in some kind of a system that can be credibly monitored and presented. So yeah, a huge challenge area.
I don't have more to add on that, but I would say that I saw another question in here that is, I'd be interested actually in my co-panelists' responses to is there anything in the IRA that addresses or circumscribes the holding of West Virginia versus EPA? I didn't see anything that did that, but I'd be interested if anyone else has a different cut on that.
No, the only thing I saw that it did is actually, there's a line in it that says, well, of course, carbon is a pollutant, which pretty much locks into place Massachusetts versus EPA, which is not a small point. Absolutely not a small point in all of that. But that's about all I saw, Mike.
Yeah, and I think that was deliberately done. So I think, going back to what the point you made earlier, Mike, is that to the extent that the Inflation Reduction Act and some of the activity that's also in the bipartisan infrastructure bill, there's actually billions of dollars in there for electric charging infrastructure, et cetera. To the extent that the combined investment plus what it leverages in the private sector, which could end up being over $1 trillion, to the extent that reduces the demand for fossil fuels, it's accomplishing a similar goal. It may not be helping out the interpretation of the world that the Supreme Court has, but it may moot it a little bit by, in society, actually reducing the need for and the demand for fossil fuels. And over time, that's what we need to do. And if we can do that through incentives, as opposed to, you know, charging the bad and letting the good grow, as opposed to incentivizing the good. So,
I agree. And just really quickly, you know, because I know doomism is so common on these issues, but we did a paper called Forks in the Road a few years ago, which you could Google and find. And we concluded that, and some people on this call may know this better, but that if you can decarbonize the grid, electrify buildings and electrify transportation, you can get 70% emissions reductions. And all those can be done even in a really polarized era. We can do this.
totally.
And it may be happening already.
Yeah.
Well, it is happening. The question is it happening fast enough, and is it happening in a way that is sustainable and can be and can get to the end point? So, yeah.
All right. Well, I think the time has come to turn the meeting back to Chuck. And I wanted, before we do that, to thank everyone, all of you, the panelists, for such an invigorating and smart discussion. I've enjoyed it. I wanted to thank Bruce Diamond, who's been pivotal in pulling this together and making it work and keeping us all on task, and Beth Craig also for her part in keeping us on track and being so successful. And all the others who participated, and Chuck Alkins, who's the grandmaster of it all. I'll turn it back to you.
Well, thank you. No, there's no grandmaster here, but thank you for a wonderful conversation. And let's continue this conversation in some breakout rooms. Please stick around, and I'm going to create these using the big computer in the sky just to assign people arbitrarily, and we'll see you in the breakout rooms.